Hi everybody, welcome to a Legal Buddy. So today we will be studying a very important topic that I frequently see in every judicial service examination, that is what is the difference between void and avoidable marriage. So before we start, I want to tell this to each and everybody listening and watching this video that I provide offline lectures as well as online lectures, and the lectures that I'm currently making available on YouTube, uh, these are just the overview. Okay, so anyways, if you want to know more about my coaching classes, you can mail me at yourlegalbuddy09 at gmail.com. I will write the email ID in the description box. Okay, anyways, difference between void and voidable marriage. If void, in void marriage, the grounds apply only to marriages solemnized after commencement of the act, but in voidable grounds, in voidable, the grounds are available इन रिस्पेक्ट टू प्री एक्ट एंड पोस्ट एक्ट मैरिजेस. ठीक है, जो वॉइड मैरिज के जो ग्राउंड है वो तभी एप्लीकेबल होंगे व्हेन मैरिज इज सोलेमनाइज्ड आफ्टर द कमेंसमेंट ऑफ दिस हिंदू मैरिज एक्ट. ठीक है, और वॉइडेबल मैरिज में पहले से भी चलता चला आएगा. ठीक, द वॉइड मैरिज इज वॉइड अब इनिशियो, दैट इज इट डज नॉट एग्जिस्ट फ्रॉम इट्स वेरी बिगिनिंग. ठीक है, वॉइड मैरिजेस हो गया है कि जिनका कोई अस्तित्व है नहीं. वॉइडेबल मैरिजेस वो होती हैं अनलेस एंड अनटिल कोर्ट ने उसको वॉइड डिक्लेयर नहीं करा, तब तक those marriages are perfectly legal. ठीक है, void marriages can't be ratified by any subsequent act. ठीक है, ये तो बहुत सिंपल लॉजिक है. void मैरिज है तो भाई सब्सिक्वेंट एक्ट से उसको रेटिफाई नहीं करा सकते. voidable मैरिजेस जो होंगी, अगर दूसरी पार्टी को ऑब्जेक्शन नहीं है, दूसरी पार्टी डजंट फाइल अ सूट, डजंट फाइल अ केस इन द कोर्ट, देन voidable marriages are also perfectly valid. ठीक है, if they don't do anything and they accept the marriage as it is, then that voidable marriage will be a valid marriage. ठीक, in void marriage, it is not necessary that decree declaring the marriage as void is passed by the court. But in voidable marriage, decree of nullity must be passed. ठीक है, if you want to make a voidable marriage as void, then the partner of a husband or wife either has to go to the court and declare that marriage as void, and he has to prove that such and such marriage is void. ठीक है. Now, coming to theories of divorce, this is very important, although not very practical importance to the real life. In real life situations we don't see these types of issues, but in judicial services examination a lot of these questions do come up. ठीक है, theories. पहली theory है indissolubility of marriage. ठीक है, now indissolubility of marriage ये हो गया कि marriage is done keeping in mind the fact that this marriage will never be dissolved. It is just like a सात जन्मों का रिश्ता. ठीक है, जैसे हिंदू मैरिज में सात जन्मों का रिश्ता माना जाता है, दैट इज कॉल्ड indissolubility of marriage. The concept of marriage is sacrament. ठीक है. Next, second theory of divorce is second theory of marriage is uh, divorce at will. ठीक है, divorce at will की हो गया not recognized in Hindu law. It's a marked feature of Muslim personal law. ठीक है, whenever we will study Muslim law, we'll see why it is called divorce at will sort of a divorce. ठीक है, offense or guilt or a fault theory, this is very important and it comes in a lot of exams. ठीक है, and sometimes you will read, if you read the commentary of Hindu Marriage Act, you will find the reference of this fault theory very clearly mentioned. ठीक है, offense or guilt or fault theory. ठीक है, what does this say? It says one party has committed an offense, another party is innocent. ठीक, remember only one part in fault theory, only one party is at offense. ठीक है, example adultery, example desertion, example cruelty. ठीक है, one party is at fault. Under this theory, some kind of offense is attributed on the part of respondent. ठीक है, जो सामने वाली पार्टी होगी उस पर कुछ ना कुछ एक ऑफेंस दिखाया जाएगा. He she is guilty of committing adultery, desertion, that I've already told you. ठीक है. Now remember one thing, this fault theory came from English people, Britishers, they gave us this fault theory. Consent theory, this was given by USSR. ठीक है, what does this consent theory say? It says it was given in 1944, asked in exams. ठीक है, it says two people can enter into marriage and also end whenever they want, just like a contract. ठीक है, it is called consent theory. ठीक है, it says Soviet Union came up with the theory of divorce with mutual consent incorporated in their law in 1944. Back in 1944, so 80 साल हो गए. ठीक है, it has been 80 years. The reason for acceptance was it that if two people by mutual agreement enter into marriage, they must be allowed to repudiate the marriage whenever they want. ठीक है, same like in Muslim law. ठीक है, Another theory which is very relevant in India, and this also was adopted by USSR, but it was given by Sweden. ठीक है, very important. Irretrievable breakdown of marriage, IRB theory. ठीक है, very important. It was given by Sweden. ठीक, such failure in matrimonial relationship or such circumstances adverse to that relation that no reasonable probability remains for the spouses to again live. ठीक है, इतनी हालत खराब हो गई रिलेशनशिप की that one cannot imagine to live with one another. ठीक. Now another thing is Mortimer committee. This is very important. Mark this. Mortimer committee came up with this theory of irretrievable breakdown of marriage. ठीक है, again given by Sweden. अब हिंदू लॉ में किस किस थ्योरी का we see the use of what particular theories. First is this irretrievable breakdown of theory. Second, we see the adoption of this consent theory, and the third we see the adoption of this fault theory, consent theory, and IRB, irretrievable breakdown of marriage theory. This all can be seen in Hindu Marriage Act, and this is very important. Exams like DJs ask such घुमा फिरा के questions. ठीक है. Now, only on valid marriage can end up in divorce. Understand one thing, if a marriage is not valid you don't need to undergo a divorce. ठीक है ना. बस. अब one more thing is very important. 13(2) में और 13(1) में जो हिंदू मैरिज एक्ट का 13(2) है एंड द हिंदू मैरिज एक्ट में 13(1), दिस इज 13(1) और 13(2) में जो भी ग्राउंड्स दिए हैं दैट ग्राउंड्स आर मेड अप ऑफ फॉल्ट थ्योरी. ठीक है. 13(b) में जो ग्राउंड्स दे रखे हैं दैट ग्राउंड विल बी कॉल्ड एज ग्राउंड्स ऑफ कंसेंट थ्योरी. ठीक है ना. एंड अनदर थिंग इज यहाँ पे 13(1)(a) में जिसकी बात हुई है उसको हम लोग इर्रिट्रीवेबल ब्रेकडाउन ऑफ मैरिज. ठीक है. दिस इर्रिट्रीवेबल ब्रेक, दिस इज वेरी इंपॉर्टेंट. ठीक है, IRB वाला क्वेश्चन तो एग्जाम्स में आता है. दिस ऑल इज IRB की there has been attempt for restitution but to avail. There has been attempts to restitute the marriage but still they were not able to restitute the marriage, so the marriage has been irretrievably broken down. ठीक है. 13(1)(a) ये बात करता है. ठीक है ना. लेट अस स्टडी सम मोर इंपॉर्टेंट एस्पेक्ट्स. ये इतना इंपॉर्टेंट नहीं है. नाउ अब हम लोग डिवोर्स पढ़ते हैं क्या है इसको थोड़ा लेट अस जूम दिस लिटिल फर्दर. ठीक. ग्राउंड्स फॉर डिवोर्स. ठीक है. 13(1) बोथ रेट्रोस्पेक्टिव एंड प्रोस्पेक्टिव. ठीक है. हिंदू मैरिज एक्ट के पहले अगर वो आपका डिवोर्स हो रहा है देन ऑल्सो दिस विल बी एप्लीकेबल. ठीक है. ग्राउंड फॉर डिवोर्स. फर्स्ट वेरी मेजर ग्राउंड फॉर डिवोर्स and which is seen a lot these days, and this and a very important and a very common misused allegation by both the sides in a marriage, and that is a ground for divorce, that is adultery. ठीक है. बिफोर 1976 क्या हम लोग का स्टेटस देखते हैं. बिफोर 1976 लिविंग इन एडल्ट्री दैट इज कंटिन्यूअस कोहैबिटेशन विद एडल्टर्स. ठीक. आफ्टर 1976 अगर आपने एक बार भी एडल्टरी कर ली then that would be a sufficient ground. ठीक. एनीवेज बहुत वीडियो को लंबा नहीं करते हैं. we will be studying grounds for divorce in the next very video. ठीक है. Thank you for watching and happy Diwali.